Hans Ullrich,
Yeah.
very warm welcome to the Digital Markets Research Hub. It's my absolute pleasure to having a chance to have another conversation with you. I obviously have many questions about the function of European competition law, and maybe we can discuss a little bit digital markets, but I cannot resist the temptation to start this conversation with congratulating on this Libera Mecorum, published by edited by Christine Gott and Matthias Lamping, which just has been published a few months ago. It's obviously for them to discuss the substance of this volume, quite impressive one. I had a pleasure and honor to contribute myself with a short essay to this text. But let us talk about the substantive issues of your vision about the things. And my first question is about competition law. More generally, do you think where are we going? Are we changing gears? Do we do it too often? What's the trajectory of the development?
I'm not a prophet. I cannot tell you what the trajectory is going to be. But when you're looking back, and I mean, I started as a young assistant of Professor Steindorf at the University of Munich in 1964. So that was just 2 years after the Bosch judgment by the Court of Justice, which really gave the kick-off for the entire development, which was to say Article 85, which is now Article 101 of the Treaty on the Functioning of the European Union, is directly applicable. It was very controversial at the time because it's vaguely phrased. And the point behind this was, this meant that agreements were immediately void at the time. And then it came complications of the time because of procedural complications, which meant that you could not fully enforce the voidness or the nullity of the agreement. But the point was, it is a directly applicable rule, Article 101, and some years later, Article 102. So people have to abide by it, can enforce it either privately, and more importantly, the Commission can enforce it directly. And that was, of course, in the tradition of the rules of competition of the old European coal and steel community. Yeah? So there's a continuous line reaching even further back into the 50s. And then the next judgment of importance was the Grunde-Constant case in 1966. Because the court made clear that all the arguments against considering vertical integration agreements as being outside Article 85, now 101, all these arguments were not sustainable, and that in reality, the competition rules would also apply to this kind of bilateral agreements in a vertical relationship. The rationale behind this was, of course, twofold. One was integration of markets, because at the time, the vertical agreements, in the Grunde case, based on trademarks, in other cases based on copyright, in other cases just simply based on the character of the agreements, which under French law were considered to grant absolute territorial protection, that these were in direct conflict with the free trade concepts underlying the internal market. That was the important point at the time. And the second point behind this was the freedom of choice of consumers, that they should be able not only to buy on the other side of the Rhine at the time, looking not from Germany to France, but from France to Germany, because Germany was cheaper at the time. I myself at the time imported, when I was a student in 65 in France, I imported a radio from Germany to France and sold it there because I could make a profit on this. Yeah, you see, that was the time. Freedom of choice was the important consideration. And since that was an absolute kind of territorial protection, all considerations of paragraph 3 of Article 101 didn't come into consideration because it was a per se, developed to be a per se rule. This was the important point. And then came judgments like the United Brands case, which imposed, or which introduced this concept of the special responsibility of market-dominating enterprises. Then came the judgment in Continental Can, which said you can apply Article 102 even to mergers, which has popped up again just recently in the Towercast case. The point was, the competition rules are one pillar of the common market, complementing the principal pillar, which was the free trade principles, free movement of goods, free movement of services. That was the important point at the time, not yet establishment. Then came judgments like courage, damage claims. You see a constant line of argument in the court's judgment on activating Article 101 and 102 for a market order. That was the idea behind it. And this was not, the aim was not to, as we think nowadays, to enhance competitiveness or something like this. The purpose was to have a functioning market system. Remember the times, at that time in France, you had virtually no competition policy at all. There was just a price decree which had been introduced in 1945, so in the post-war situation of supplies in France. Yeah? So that was, in Italy, you had 2 rules in the civil code which have never been applied. In France, you also had a code, a rule of Article 419 in the penal code, which was never applied. There was no competition commission at the time existing in France. When it was done by the Minister de l'Économie or the Minister de la Finance. Yeah? So it was not just simply not existing. The only country at the time which did have a working competition law was actually Germany. And even German competition law at the time was different from what you imagine today, because at the time, our rule on the abuse of dominance was not directly applicable. It was a privilege of the Bundeskartellamt to enforce this rule because we thought we had to develop on a case-by-case law basis when it should apply. And we didn't think we could leave this to private enforcement. So it was a totally different kind of thing. And from this it went on. And then it was slowly that the ideas about competition developed. We were looking mostly at the time to the United States. But at the United States, the system at that time was a liberal system. It was long before Chicago. And we just simply admired it as it was. And we took up, at least in German doctrine, we took up this American strand, and we continued a German strand, which is the famous ordoliberalism. And we looked a little bit to the Netherlands, and we looked a little bit to the UK. The UK at the time, it was they did have a competition law, but they were not just yet in the common market. They joined later. But when they joined, still they did have a competition law, but this was a very complex and slow-moving kind of thing at the time. And then came the theoretical developments in Germany, pushed mainly by Messmaker, I must say. But it was an entire school. It was always, funnily enough, it was always private law professors. It was Messmaker, it was Steindorf, it was Fickenscher, these Biedenkopf at the time. And the idea was freedom, for competitors, not freedom for the people who conclude a reciprocal agreement, freedom of competitors. It was the freedom of choice on the upstream and downstream markets. It was the idea, which was very strong also, that competition is an instrument of containing the market powers of enterprises. I'm not talking about abuse of dominance. I'm just simply talking about the general effect of competition law. The term used, I don't know how to translate this into English, is Entmachtung. Yeah? Contain the power, or really disempower enterprises. Yeah? Which, of course, is a problematic term, because in dynamic competition, you always have some market power. People strive for this, yeah. And the entire point is that competition should, on the one hand, allow, and on the other hand, restrict the exercise of market power. That was and that is a contradiction which you have running throughout the system. It was an important point at the time, and the European competition law at that time, I'm talking about the 60s, late 60s, the 70s, the early 80s. And it was only then that slowly, at the end of the 80s, beginning in the 90s, the problems shifted. We realized, because competition law was fully developed already at that time, then the basic concepts were there, that the Commission could not handle this under the system which it had established, that Regulation 17 from 62. And that regulation was important in the beginning to provide for the Commission, at the time the only competition authority, aside of the German, was not that important, was it needed information of what was going on in the market. And therefore we had the notification system. And the lesson which they had to learn is that industry could flood them with information. That is what happened with these thousands of notifications of licensing agreements and of vertical agreements and of all this stuff. The Commission realized that it could not work with that burden. It could not handle competition law by giving from time to time negative clearances, because the effect of the notification system was that it blocked the exemption rule. And from the beginning, already in the Bosch case in 62, the court had said that Article 85, paragraph 1, and Article 85, paragraph 3, so 101, paragraph 1, 101, paragraph 3, form an integrated rule. They have to be applied both at the same time. And it is only for procedural reasons that Article 85, paragraph 3 does not come into effect immediately. But the idea was from the beginning, you do not have only a prohibition, you have the exceptions, and both are on equal footing. And that system did not longer work under the Regulation 17 from 62. That is why it had to be, why they gave it up. Plus, of course, other considerations. Other considerations were, at least my recollection, in 1962, we were 6 member states, relatively homogeneous. In the 70s, we have become 12. In the 80s, we became 15 and more. That was no longer manageable. That was a different kind of European community. And when you, and remember the concept of the court has been also from the beginning that interstate trade, in American terms, so cross-border trade, that criterion of an appreciable effect on trade between member states exists even for small agreements. Now you have all the agreements in Eastern Europe. You have all the agreements, I don't know where, between Austria and Germany, and it's just simply too much. You have to have, if you wanted that this system to continue to work, you had to change the approach. Thus, at that time in the 90s, this change of the approach that economists became interested in the matter. That was not the case in the 70s or 80s. We did have in Germany a discussion with economists, but that discussion was, looking backwards, entirely fruitless, because it turned about the concept of whether the light bill, the model competition is atomistic competition. And the model would be fully transparent markets, easy access for everybody. So something which exists in theory, which is a totally static model, but which doesn't exist in practice. And with that, of course, that runs afoul. And I think it was in the mid-80s that our Federal Supreme Court said, no, that's all wrong. There needs to be some intransparency in the market, which allows people to make first moves, profit from first mover advantages, and these kind of things. So all of a sudden, we became more realistic. And at that moment, the economists came in, and you had the American development of the Chicago School telling us some lesson, always from one model, of course. And that model came into our discussion as well. And the problem then for me was, and still is, that when I was faced, it's the first time I had the pleasure and the honor of handling a case for the Commission in the late 70s or 80s, of course we used economic arguments. And the Commission did use economic arguments, but these were, so to speak, supportive arguments, not the central arguments. And that changed. That changed, and it did change because economists cannot work with normative assessments. Freedom of choice is something which they cannot put in numbers and are very difficult, or only with great difficulties, very complex models, and they need to have models where they can change 1, 2, or 3 parameters, and if it goes beyond that, they have a problem, a normal problem. Probably no longer with artificial intelligence, but at the time there was a problem there. Which meant that all of a sudden, and that was also the mood of the time, efficiency in economic terms, the welfare standard, became the master standard for assessing competition law issues. And the problem was that, at least in doctrine, and that was true even at the time when I was in Florence, and I discussed this several times with Massimo Motta, the reality of competition law is you always have several objectives at the same time. And you have to see which kind of restriction addresses which kind of objective, or put it differently. When you develop a theory of harm, as we say nowadays, you have to define the harm you want to address. And the harm can be either it blocks innovation, it blocks output, or it blocks freedom of choice. And therefore, these and this is also true when you look at the Court of Judgment's case law, the court never abandons the idea of that there are additional goals, which is different under Article 101 and 102 as compared to the merger control. In merger control, and probably with good reason, the main standard is efficiency. Does the merger allow the enterprises to enhance efficiency? Is there enough competition in the market to make sure that this efficiency will really be brought down to the consumer? That's the test in merger control. But when you're talking about cartels of various kinds, then you have immediately the consumer interest on the hand, you have the freedom of choice interest, you have the competitors in the hand. You have to see this. Competition law, you suggested this in your question, but competition law was competition policy, at least as far as I can see this, was never in the interest of enhancing the European Union's international competitiveness. That was not a purpose. It was the functioning inside the market. International competitiveness, this is something which you have, of course, because always this sounds nice. Second, because of course you have to see that European industry does not lag behind the United States or China. You did have something which we are no longer aware of, but which was in the beginning very strong. The model image of the European Union was have a market like the United States. A market which is large, so you can reach economies of scale. A market where you have free trade, so you can optimally allocate resources, that you can find the place where you can best work at the lowest cost or the best resources. That was a model, but it was not that we would try to match the United States. It was a matter of how could we survive as Europe. That was our idea, always seeing the catastrophe which we had just behind us. And until 1985, the contrast with the Soviet Union. So that was our interest. International competitiveness, that played a role, of course, when you look to trade policy, when you look to intellectual property, when you wanted to go on other markets. There was, of course, a problem. But in my work, or when I look at the literature on our competition law, what I have seen was there was no argument in Hans. It was an argument of it's fast. Okay.
And obviously, this really illuminating answer raises follow-up questions, and I wanted to ask a couple, if I may, Hans. The first one, you mentioned in passing that the center, intellectual center for European competition law was based or emerged in Germany, with ordoliberal tradition, Freiburg School. We all are mindful of the names and concepts or labels, but not many know the mechanics. And you mentioned one very important element, which I think has not been often articulated properly in the discussions, unless by really experts or economic historians, that they come from, they are private law professors. Mm-hmm. Those who were implementing the ideas of Freiburg School into European competition policy. And you stressed it, so it's not an accident. So can we infer from this that the concept was not a top-down approach, as would a public lawyer somehow try, or constitutional lawyer try to envisage the system, but was rather kind of was driven by the interest of private parties. You said the right to compete. And so that's the main kind of DNA of European competition policy. Rather, should we? What's the role of droit propriétaire in this discussion? Because many people try to unravel the core of it from there.
Yeah, because there was a discussion in which you can read when you read about the conference and the report of Medina on in 1955. How to approach integration. And there was always a conflict between the institutionalists, which was the public law constitutional lawyers, and the, how should I say, that was a top-down approach, and the other one was always a bottom-up approach. It was always the idea to have the citizens move forward with this. And behind the court, look at the Enel Costa judgment of the Court of Justice. It was exactly this. Have the rules, give them direct applicability, and see that people defend or claim their rights. That was the idea. Yeah? That runs through the entire development of European integration. Yeah? Now the problem of the time was, and competition law fits perfectly into this. And in Germany, the ordo-liberal school, Eucken was an economist. So he was seeing this and how the national economy would work best. Yeah? The main defender of its ideas in law was a private law professor, was Franz Böhm. Yeah? And the relationship comes into via corporate law. Because when we set up our first competition law regulation in 1923, it was based on how cartels are organized, and the main sanction against this was voidness of the rules which are abusive of market power. Yeah? That was the idea at the time. But this was a corporate law approach. And it took us quite a while, again, it was Böhm and it was Messnecker and these people, to say, we are not interested in the organization of a cartel, we are interested in what they do to the market. And that was a change. This is nothing which was in the mind of many public law lawyers who organize the state. When you can draw a further line, at least in Germany, in post-World War I, when we had the huge economic crisis, it was a crisis on how do you pay your rents for your apartment and for your house, yeah? How do you do your living? And on the basis of freedom of contract, that didn't work. And it was a private lawyer who came in and said, we have to have a duty to supply, which totally breaks with the general principles of civil law, Kontrahierungszwang. And the man was Ernst Nipperdey. Nipperdey was, in fact, a labor law lawyer, who later on became president of, after World War II, president of the German Federal Labor Law Court. Well, that came from a totally different direction, always looking at, we have to deal with the problem which we have at hand, and not with the beautiful things. I'm exaggerating a little bit, because there are also public lawyers who understood this and did this, and the Weimar Constitution was very much about social rights and these kind of things. So it's unilateral what I say. But the point is, the roots of competition law in Germany have always been private law. Goes back, that the first discussions also goes back with the economists, goes back to 1905, when we had the first, and we never never agreed at the time, because you know all the story with the cartels and the cartels supporting the being the backbone of the war and weapon supply of the German army in World War I, and all these kind of historic things. That's not true. So that's just to say why it was private law. Of course, I mean, after all, there was an approach also. It was Forsthoff, who was saying that competition law is police law, and that simply didn't get grips with the things. It was an approach, but it didn't get grips. It's a question of mentality. In France, yes. In France, it was always administrative law.
And this is, obviously, every second paper, my colleagues who I admire very much, refer to competition as essentially contested concept. So it's a luxury probably for our area that it's constantly rediscovering. It is quite amorphous, and it can show to us from different perspectives simultaneously, and thus it's evolving. It's not very fixed and very stable. You mentioned that in France, the vision is more from the administrative law, and it looks that now, at least when we talk about ex ante new wave of ex ante rules, that the vision is shifting towards more top-down approach, towards more kind of. In UK, we have one of the iterations of Digital Markets Competition Consumers Bill was called New Pro-Competition Regime for Digital Markets. So the regime envisaging more proactive role of the authority and the government to tailor.
Yeah.
Is it a new trend?
Yeah, you must see that in the UK, there is no distinction, at least not firmly established, as far as I can see this, between public law and private law. Whereas in France, the entire system is built upon that distinction between administrative law, droit administratif, et droit civil. These are two totally separate branches with totally separate judiciaries. Yeah? And the state controlling the economy would rely on administrative law. The 1945 regulation was called price regulation. And in Germany, Germany took over administrative law from France. So we have so we are in the same tradition, like most continental laws, Italy also. We are in the same tradition. And the only is the question, who comes first into contact with the conflicts raised by cartels? It's of course the private lawyers. Because what happens when somebody in the cartel doesn't abide by the rule of the cartel? It goes to a civil court, if it ever goes to court, or to arbitration.
And this leads us perfectly to the paper, one of your recent papers published in 2021 with the name "Private Enforcement of the EU Rules on Competition: Nullity Neglected." Can you just very briefly outline the concepts? Obviously, you have provided the background, non-intentionally, implicitly to the paper, but you discussed there several very important elements of EU private enforcement, but more generally of EU competition law.
You know, when as a professor you are writing, at least it's true for me, there are professors who work systematically. I'm not working systematically. I'm working ad hoc. When a problem pops up and I find it interesting, then I get into it and work on it. And I just simply realized that in UK terms, the antitrust defense was very popular when the UK joined the common market. Namely, the defense of the contract is void. That was the antitrust defense. In licensing, in vertical distribution, and these kinds of arrangements, this is where it was important. And that was in the 70s and 80s, and then for 20 years, nobody talked about it anymore, more or less. Whereas in Germany, there was always a doctrinal discussion on what the nullity, which we also have in our GBB, it is what we call a Verbotsvorschrift. It's prohibiting. The consequence of prohibiting a contract between people is nullity. We had always a doctrinal controversy about what does this really mean, and what does it mean then when we transpose this to the European competition rules. And my starting point was just simply to take that discussion up and bring it to again to the level of the European Union, also because the actual cause why I was writing this was a copy of what was a number of the IIC of that journal, which at the time was International Competition and Intellectual Property Law. It was a lawyer, Jochen Pagenberg. And I think it's a good idea to dedicate something which has a practical effect to a lawyer. And I have two basic points in that, or three probably. The first point is the nullity is of a horizontal agreement is the exit route from the cartel. It allows everybody in a horizontal agreement to leave it without any risk of being pursued because the cartel is void. So it's an exit route and it protects this. And I was aware of cartel theory, and cartel theory is price cartels usually do not hold very long. There are exceptions to this, but usually they do not hold. And price cartels do have some prerequisites. One basically is it must be a more or less homogeneous product. It must be one where you can control the prices relatively easily, and it must be a more or less not tight, but an oligopolistic market, because otherwise the surveillance costs for the cartel become too excessive. That was one idea. Activate the exit route. And the other one was, that is, I think, very much a German thing, but it applies also. The Court of Justice never entered into this, was just simply not asked, especially is, when you have a cartel and the cartel people are making contracts, then the question is the contract, the subsequent contract, affected by the nullity, yes or no? And the distinction which we make is that the contract which when you have, for instance, a quota cartel, or when you have a cartel where the people are a cooperation agreement, where people supplying each other at fixed prices, is that the agreement between cartel members implementing the cartel are always caught by the nullity rule. That is not the problem. The problem is the sales contract, which is based on the price set by the cartel. Is that valid or is that invalid? This is what we call the follow-on contracts. And my point was, we can, the general argument is, if we have the follow-on contracts caught by the nullity regime, then the poor consumer is at a loss. And my reply was to this, wait a second, look more precisely at what kinds of contracts you have. If the contract is, so to speak, infected by the agreement, the price, then I would very much say, yes, nullity. You get your price back. You do not even have to bring a claim action for damages. You may bring the action for damages in addition. But that is the first point. Whereas then you have other kinds of follow-on contracts in cartels, when you have cooperation agreements of various kinds, and the cooperation is void because it does not sufficiently contribute to technical progress or this kind of criteria, that you do not see in the follow-on contracts. These contracts should escape. That was one point I was trying to make. And the next point was, because that is very little discussed, is the nullity regime must also apply under Article 102. The abusively set contract conditions, abusively set by dominant enterprise, must be caught by nullity. But you must be careful now that the nullity does not work to the advantage of the dominant enterprise. So that they can, so to speak, rescind the contracts which they find no longer advantageous. But it works only in favor of the consumer. It is a unisided way of protecting. That idea I tried to bring forward. Also because I was, and I still am, distrustful of the effectiveness of the damages claims, which I think are important, but takes the price cartel in the drug case, where we have so many litigation here. The nullity is the first thing. You have the cars, you don't have to pay the price. You have to rearrange the contract on the basis of unjust enrichment rules. My point here is you give an additional means for the consumer in the car of trucks. The consumer is not the end consumer, it is a consumer, an industrial consumer on the market. It's the German railways, it's a transportation firm or somebody else. Let them fight this out and have nullity there. That was the entire idea. It's just simply activating. You see, the nullity sanction has one big advantage. It is immediate. And you can always rely on it. And that was very much discussed in Germany. You see, you have, the example is a licensing contract. You have a licensing contract. The licensee says the contract is void because it violates Article 101. And that the licensee says after 10 years of the licensing agreements working and the licensee benefiting from the licensing agreement. And then the patentee, the licensor, comes and say, you see, that's against good faith. And the answer of competition law is we don't care about good faith in competition law. We want the damn thing to get rid of, to be void, to get out of the world. That's the point. So it's, for a civil lawyer, it's an unpleasant sanction. For a competition lawyer, it's the right thing to do.
But which do you? How, okay, from civil law and civil lawyer and competition lawyer, the difference is clear. But if you look at competition law as public policy, can we say that can the use of private tools be excessive?
Virtually not. There may be exceptions, but that was also in the mail you sent me. The fact that competition law is private policy brings us back to to our starting point. Competition law is public policy, but environmental law is also public policy. And large parts of social law are public policy. And consumer protection is public policy. And what we have in the EU is, throughout all these fields, private enforcement. Because it is the individual who is concerned and affected by whatever kind of misconduct we have. The free trade principles have been activated by the Court of Justice via the direct enforceability. And you need to show me a case where private enforcement really runs afoul of the public policy goal. The public policy goal is already defined in the substantive rule itself. In Article 101, you have the public policy in two forms. One is the restriction of competition, and the other one is paragraph 3, the positive effects of some restrictive agreements. Where is private enforcement hurting this? You see the patent in my example, the patentee, the licensor, who was giving the patent, made a profit during all this time. Also, both benefited in reality. To make a real good case of what the argument was of venire contra factum proprium, you really have to show that both knew that it was running afoul of competition law. And then we have a rule under the rules of not of fairness, of good faith dealings, where say if both acts, there's a Roman saying on this, in turpi dubine, then no claims. But must be both.
Okay, but would the situation? Okay, you mentioned competition policy as a police earlier to in the conversation, and I accept that for traditional ex-post mechanics, the more the better. And basically, if we disseminate the power or interest to the parties who are directly affected, we can incentivize the process, and it can go from different directions. And thus, all in all, it will be better performed. The more enforcement, the better for delivering of this undefinable competitive process or defending consumers or innovation or efficiency. When we move to ex ante, when we move to kind of new regime, sui generis ex ante, it's not so ex ante sectoral regulation as we knew it with liberalization policy, where it looks, at least in the UK, where the obligations themselves are not defined even, where the enforcer got full discretion to select from the open-ended catalog of obligation anyone and then refine it accordingly to the context. Doesn't it appear to be that the fruit is hanging too low in order to disequalize this asymmetry of information and in order to speed up the process for public enforcer? But should we automatically, or would your vision automatically open this very toxic or very hazardous toolbox for all private parties, included third-party funded litigators who have very trained muscles to problematize even most innocent obligations, let alone such generously granted for the reasons which we all understand? Does it change the parameters of the game which we are talking about, or it only incrementally?
Yeah, that is you of course you are alluding to the Digital Markets Act. That's behind your mind. You see, when I mentioned earlier, when we in Germany had in 1958 enacted our Act Against Restraints of Competition, we had an article, I think it was 20 at the time. No, it was not 20, it was a different number. Anyway, the idea was abuse of dominance. We do not know exactly what abuse really means. And therefore, we want only an administration handle these cases, not private parties. And this is why during almost, I think it was almost 20 years, that we kept that rule, and only once we had some cases, both on the national level and on the European level, and we know that the people are more familiar with the competition law system, that we changed this into a directly applicable rule. And the fact is that this directly applicable rule was applied relatively rarely, and in private litigation also relatively rarely, because the risk of litigation and of losing before the court just simply was too high because of the uncertainty and the vagueness of the terms. What is an abuse? And with this in mind, And yesterday I looked again at the Digital Markets Act. I'm not a specialist for the Digital Markets Act, I must say. And going through the Digital Markets Act and looking at under which conditions you designate somebody as gatekeeper, and then the kinds of obligations which you impose in it under Article 5. And then the obligations under Article 6, which can be implemented by the Commission according to Article 8. And when you read this list, at least I get worried. That's what I already had earlier. My intuitive reaction for the master example, self-referencing, was that's what all people do. We as professors do all the time self-reference. We cite our own articles first, and then these are the others. I mean, we should not, but we do. So this is, so to speak, a sort of a, there you have to find out when is self-referencing a problem, when isn't it a problem. This is the same kind of thing which we also had with tying clauses. I always was, contrary to the economists, very worried about these tying clauses because I think it's a direct impact on the freedom of choice of computers when people say you have to take the two. And I was very much in favor of the earlier American case law, which said whenever there is a slight exercise of market power in the facts, then it's unlawful. I was very sympathetic to this. This was also in the under German unfair competition law. Well, that was the characteristic. But I admit, of course, that there are also good reasons for becoming a little bit less critical of tying because it has economic benefits. So how do you find this out? And this is a slow process, which we see under Article 102, how the case law develops there. It's very hesitant and careful and trying to mark the lines clearly. In the Digital Markets Act, the Commission has free rein. And that is something which would worry me, even though I admit that what we have in with these GAFA, with these big firms, is terrifying. But I'm not sure whether we have whether this is the right way. And then I, because you asked us in your mail already, and I tried to think about could private enforcement become a real problem there? Who's going to be who's going to bring a suit against Google or against Apple on the argument of this? What is the possibility to show the damages, the harm? It's going to get very difficult. Therefore, on the one hand, I'm very critical about this broad approach. On the other side, I think I'm not sure whether it's been really harm. But what I see as a real problem is it gives much too much power to the Commission. I mean, it's a sweeping kind of thing. If you go to the many rules where they have delegated powers under Article 12 or 15 and 46 and so on. What is going to happen there? In the long run of, let's say, 10 to 15 years, I would say what's going to happen there is enhancement of the powers of the Commission, transforming into bureaucratic capture, because the European Union cannot do without these big firms. And in the end, we have what the political science people already say now, we have the info imperium by both the big firms and the European Commission, because they were trying to enforce, they must enforce something of it, but they cannot enforce it full as with all the potentials that politically is not possible, and we are going to get I think, an unfortunate mix at the end. But this is just, you know, a general worry which I would have. And when I look at these markets, I'm always surprised. I have no explanation. For instance, in Germany, Google has a market share of 90% for the search engine. In the United States, it's only 60% or less. The other 40% are blinked by Microsoft. Why are we Germans so dependent on Google? What's the reason behind this? Is this all network effects? Or is this mentality? Is this the first mover advantage of Google? They were first in the market in Germany. What is it? And I would certainly take a bet on that the European Commission with the DMA is not going to disempower these big firms. They are controlling them. They can, with all the machinery which they have there, all the tools, and they can control at the margins. But the basic roots of the sources of the power of these firms, the network effects and the first mover advantage and the innovation potential which they have developed and the huge amounts of data which they already have, they will have produced the effect also in the future. There's not going to be a change in that respect. And therefore, what's the use of the entire thing? How does it work? I'm not saying that we shouldn't control. And I'm certainly particularly worried in the field of what they know as the Digital Services Act. So in that political field, but this is a different kind of thing. I look with fascination to two things. One is that competition lawyers are the most critical of the DMA. Why? Because they are losing a field of law to a newly developing field of law, because that's going to be a highly specialized field of law for experts only. It's not for the general competition law anymore. So this is an interesting thing to see. You know, we have professional interest in not having the, and therefore this broad discussion on whether competition law could apply in addition to the Digital Markets Act or not. The second thing is, which is, I think, is still more interesting, is that's due to the Facebook case by the Bundeskartellamt. All of a sudden, we have again a discussion on the relationship between free markets and democracy, and competition law as the means to ensure free markets. We have monographs there, we have articles there. All of a sudden, we also have a resurrection of this freedom of choice idea. It's coming up because they see, oh, what's happening there is really dangerous. And it is. The Facebook case, I would have been able to solve, like the Bundeskartellamt. I do not need reference to the democracy to fight my Facebook case. That I can do on competition law terms. I have no problems there.
Neither to GDPR, actually.
Yeah.
But I'm very grateful you mentioned this new hype with democracy. It wasn't the case in 2009 when we were working on these issues at European University Institute. So I'm mindful of time. Let us move more to sociological aspects, because you are such a treasure of views, not only experts but also about the profession itself. I wanted to ask you, what is your observations about academic life, maybe in Florence and in Munich, in Max Planck Institute for Innovation and Competition? There was a recent ASCOLA event, and the institution was called Max Planck Institute for Competition and Innovation. And Joseph Drexler was mindful to stress that the name is Innovation and Competition. So maybe about ASCOLA, Florence, Munich, and maybe also how is academic life changing? And again, you are not prophet, but your intuition and knowledge is very strong, maybe where we are moving in this, more niche thinking, more special, nuanced technical expertise rather than kind of broader societal vision?
No, the Max Planck Institute, that is something about the growth of the relentless growth of institutions. When I came to the Max Planck Institute, first 1970, that was a highly specialized institute on intellectual property only. And I came there because I came from the university and knew something about European law. And the idea was that I should bring in European law into that institute. And what I brought in was competition law. And then this broadened, and then we became more critical of the IP fields, and then we wanted to have economists, and all of a sudden there was a need to call it innovation and competition. And this is a little bit of a pretentious name. It's a little bit too broad. Anyway, my concern with, let me put it differently. When Steindorf, so to speak, where I did my habilitation, was a professor in the old German tradition and also a little bit in the now existing American tradition. He had a broad chair, European and international economic law. He was a very independent person. He was well paid. And when he retired, he was an emeritus, meaning that they would pay him the full salary even after retirement, full salary. When the next generation already, that was not me, that was one before me, did lose the privilege of the emeritus status. They got a pension only. I'm still in that group, but my successor group is no longer as well paid as I was, but paid less, and then they get the pension. And if as a professor they want to have a little bit more money, they must excel within the universities, and they get some additions, or they go to consultation and make this kind of thing. What I'm trying to say is that the usual professor's job is sort of degrading. And the reason for this is that at the time of my father, we had 100,000 students in Germany. At the time of when I became a professor, we had 1 million. Now we have 2 million. You cannot afford as a country to have 2 million people taught by well-paid, a few number of well-paid professors. That doesn't work. So the system is going to change necessarily. And it's very important that it changes because we, of course, want our young people to get better education. So that is no problem. It also means that's the reverse side, that all of a sudden you have, again, a need which was not at my time when I started studying and when I was assistant, we did not have elite schools. The term elite was not accepted even. It was arrogant, elitist. This we have. Now we call it, instead of elite, we call it excellence. But it's the same thing. You have excellence universities. You have the Max Planck Society, which is on the top of better paid and everything. Which means you're getting into a split of the institutions. And that split is, at least in Germany, even covered because now what formerly was a Fachhochschule, a specialized professional school, vocational school really, is now a university. So that is formally upgraded, but de facto downgraded. Whereas the Max Planck Society and some of these other institutes, also in the economics, they have an exceptional role, exceptional position. And in a way, this is frightening. But you have the same kind in the United States. When you look to the United States, you have probably 10, 12 real top universities, 20 to 25 excellent universities, and a huge mass of other universities. And we are always looking to the United States to these 12 or 20 or 25 universities. We are not looking to the others, which is a mistake. You see, this is the problem. And now, I think I was relatively fortunate because I'm still the generation who benefited in a way from the old system, and I could do lots of my work as I wished to, lots of it. From the Max Planck Institute, where I came from the university, went to the Max Planck Institute. Then I went back to the university as a professor, was at the Bundeswehr University, the University of the Federal Armed Forces in Germany, which is a civil university, in fact, but which is, of course, a little bit marginal. But it had the big advantage was the economics department. I could do what I wanted, more or less, which I did. And then I became got several other offers, but the final offer which I had was in the European University Institute, which is a privileged institution as well. Highly privileged. Yeah? Only doctoral students. Right, they had the masters, but it wasn't. That was what the main thing is. That's very privileged. Yeah? So I had this, but it was never programmed. It was never planned by me. Right? You cannot plan your career. My advice and that's an advice I give to all my doctoral students and to everybody all the time, is to say, do what you like. I think I told it to you also. Do what you feel you need to do, and then you will find the ways to do it. That was the recipe. And do not try to. Of course, it's a little bit more complicated because you have family and you have children, and you must see that you. All this I know. But the red line, so to speak, as the fil conducteur, is try, because otherwise, if not, then my advice would be go in a law firm. There you can really earn money. But then there's all the other problems which you have there. My father was practicing attorney at the time when an attorney was still an attorney. And the big law firms were not yet existing, at least not in Germany. You know, the field has enormously changed. When I came to Paris in '65 and I learned that there was a law firm like Cleary and Gottlieb with hundreds of lawyers, I was just simply amazed. Didn't know this before.
ASCOLA. It's a big success story, really remarkable impact, growth, and it's a place where all competition lawyers aim to come annually. I remember when it was a small gathering of like-minded people coordinated by yourself. Can you just very briefly outline some historical pedigree of the institute of the organization?
For me, there was a very simple reason. And that's also true for Josef Drexler, who was right from the beginning was with me, and Roger Sech was with me. We were together, we were not busy. We were just simply a group. Josef Drexler was the youngest, Roger Sech is my age. It was a very simple reason. The only cartel antitrust law association existing, at least in Germany, was run by lawyers of law firms and of lawyers, so syndici of industry lawyers. No academic society existed. And I knew from the IP field, where we have an association also, which is the KUR, the Gewerbliche Rechtsschutz- und Urheberrechtsvereinigung, a huge association, where you have a mix of the two, academic and others. But I knew from this that the academics, they allow them to speak with it, but they are not listening to them. And I wanted to have, and we wanted to have one where we can be more independent. That was the reason behind ASCOLA. And then it just so happened that first, I felt the support of the public officials from the Bundeskartellamt and from the European Commission. I had a workshop in Brussels 2 or 3 years before where I felt the support. Then I had the opportunity to come to Florence. That was a good way to invite the people. So the opportunity was there. And we benefited from the opportunity. We found that we had no hope and no expectation that it would become that a large association. I had a model for this, which is the French Association Internationale de Droit Économique, the international, also mainly by academics, with some faculty lawyers in there. Also, totally independent, a little bit of leftist association. And I wanted to have not a leftist, not a rightist. I wanted to have just this kind of thing. And then it was the merit of, not of me, it was the merit of Joseph Drexel, of Paul Nihul, and then of Michal Gall. That is really, she was very energetic and she did a lot. And people like you who took up the baton and brought it forward. It's your merit, it's not mine.
And now we have new president, of course. And last question we traditionally ask for advice. You already mentioned some, but I wanted maybe if you can combine it, I wonder, with explaining or maybe suggesting your daily routine. How does it work? You deliver so much for so long time. It's really remarkable. You keep impressing the readership with this bright, very condensed ideas. You have to read your paper with pencil and very carefully in order to decode all the messages. How would you share this? Obviously, it's a matter of luck. I know you mentioned it to me before we start talking.
Look into my room and you see the chaos. So I'm working from the chaos. No. As I said before, it's not planned or programmed. It's just simply that I feel that this is what I learned from my professors when I studied in Tübingen, how you do academic work. I'm not doing it systematically. I do not have a live program. There are different categories of professors. There are some who like writing a treatise on the law, comprehensive work. That was, you have to do it when you write your habilitation, and one should write 1 or 2 other monographs, of course. But writing a treatise is a different thing. That's a life exercise. And some do this, and we need them, and some are terrific. It's not my way of working, just simply. Also, when I did my habilitation, I said, you cannot write a book on 400 or 500 pages no, you have to subdivide it into chapters, and these chapters are like writing articles, and you have to see that the entire thing then is consistent. And I'm writing my papers. I'm writing papers like like Steindorf did. He did only a small introduction to economic law, but basically he did write articles on the point papers. And now, since you are saying you're reading it with a pencil, well, I'm writing them with a pencil. I'm not writing them with a computer. No, it's all handwritten, and that's old-fashioned in a way. Trying to keep it within limits, but that's it's very individual. Everybody does it his or her own way. You do it yourself a different way.
And obviously, I really look forward to start waiting for the next volume of Liber Amicorum. In 5 years' time, usually the tradition goes. So the time goes quick. So we look forward to contributing and to reading, of course.
Yeah. Okay, I'm going to read it with pleasure because I found that on first glance it looks very, very appealing. Yeah.
Great. Hans Ullrich, thank you very much for sharing your brilliant ideas with all of us.
Thank you. Thank you.